Bev takes her glasses off. She is staring at Brennan. Brennan shakes his head. Auntie Bev nods and puts her glasses back on. Non-verbal communication between a lawyer prosecuting Karen Read and the judge in the Karen Read case. $10,000 I would put right now, ready to lose it, because I think I would win it. Listen to this. Brennan and Bev are having ex parte communications behind the scenes. Yes, I've just said it. That is a violation.
Probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5.
Brennan just looking stupid and idiotic and making a fool out of himself. Folks, we now have evidence of collusion. Evidence on video. Well, hello everybody and happy Saturday. Welcome back to Buckle Up, It's the Law with your host Larry Foreman, also known as the DUI Guy Plus. Today we are going to jump right into the ARCCA videos with Dr. Wolfe on the witness stand. ARCCA, folks, are the people that Auntie Bev and Brennan both were trying to keep out of the jury trial. Why? Because they are going to explain that there is no way, no how, no possibility in this universe that John O'Keefe died by car accident. That's right, folks. And finally, Auntie Bev buckled. Hank Brennan buckled. I'm foreshadowing right now. I am telling you these witnesses are coming in. And this is one of the most explosive pieces of testimony I have ever seen in a jury trial from an expert witness. Remember, this is not Jackson or Yannetti or Little or Alessi. This is Brennan. This is Brennan trying to disassemble a witness. Spoiler alert, he fails so miserably, so badly. You have to see it. Let's check it out.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Oh, and in case you're wondering, the jury is not in the room. This is something known as voir dire, voir diring a witness, also known as testimony by avowal, A-V-O-W-E-L. Those are legal terms. You don't have to worry about them, but just so you know, there is no jury in that courtroom. They are not hearing any of this.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Miss Little, last year I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to... Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time, who did you correspond with by email on the defense?
It would have been Mr. Jackson, Miss Little.
And it's like he's in the hot seat, but you can tell he doesn't care because he's got nothing to hide. Ladies and gentlemen, here is an honest witness before you. Watch his body language. I don't need to tell you this. Your spidey senses are not tingling. You can tell he's like, what do you need? Can you give me a time frame? I'll give you an answer. You're just being so vague. Intentionally. Brennan is trying to trip him up intentionally to make him look like he's a deceiver. So he's not letting Brennan paint him as such because he's giving him direct, honest answers. Watch his body language.
Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yeah.
And by the way, for those of you who watched my Jennifer McCabe video, you may think, wait a minute, he keeps looking to his left. Is that his fabrication access? Some people, it's flipped. You have to be mindful of that. So it's you can't just look at them one time and they do this and that means something. With Jennifer McCabe, it was very simple because she just kept accessing the same lie database, the lie bank that she has. So that was easy. With Wolfe, I think some people have it flipped. It's about 5% of the human population, I think, according to Joe Navarro, who I shouted out in the previous video. Shout out to you, Joe, again, for what everybody is saying. Former FBI agent that helped train me, amongst others, in body language. When you look, some people, this is a lie. When they look here, that's their fabrication database. And here is the memory bank. And I think with Mr. Wolfe, actually his left is his memory bank. You'll see he keeps accessing it over and over and over and over again. And he's an honest and truthful witness who has nothing to hide. He's going to tell Brennan everything. And watch how he slowly, methodically makes Brennan look like a fool. This is actually the cross-examination of Hank Brennan by Dr. Wolfe. This is the reality of it. This is the cross-examination. You heard that right. I did not just have an aneurysm. This is the cross-examination of Dr. Wolfe cross-examining Hank Brennan. Even though Brennan is the one asking the questions, you'll see what I mean by the time the video is over.
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. No. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So, are you finished with your answer, Dr. Wolfe, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So, as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
So when did you become an advocate for the defense? Do you
What?
feel like you're an advocate for the defense?
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about...
That's important because he didn't just delete them. He deleted them in the regular course of business. If he deletes text messages in the regular course of business because he has a lot of privileged communication with attorneys, I think it's actually a smart move to delete texts. Now, when lay witnesses, such as the McCabes, the Alberts, when they delete witnesses, it's suspicious because they're not employees of the court or you know, the system. I mean, Brian Albert obviously was, but still, he doesn't delete text messages in the regular course of business. ARCCA people are very specific. They work with attorneys exclusively, probably like 99% of their businesses with the courts and attorneys. To delete text messages in the regular course of business after business is concluded, there's no problem there. I don't see a problem there. I would actually be thankful. It makes me want to hire this guy if I ever need him, because I know that 3 months after the trial is over, if anybody tries to like subpoena him or whatever, the text messages are deleted in the regular course of business because this is a privileged communication between an expert and an attorney. So if he deletes text messages in the regular course of business, where's the problem? And he deleted those, where's the problem?
Scheduling or meeting, or hey, can we meet at this time, or show up here. I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
What?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank
No,
you.
he did
How
twice.
many texts did you delete?
I don't know the number, sir.
You don't know the number?
I don't have the text. So you're asking me over a year ago almost
I think in this moment right here, in this moment in time, when we are about 1/5 through this video, you can see how Wolfe is smiling. He's relaxed. He's happy. He's telling the truth. He's telling exactly what he did. Yeah, I delete messages. So what? Brennan, I'm sure, is like, oh my God, I just hit a gold mine. I'm going to have a field day with this guy. I'm about to obliterate the defense's witness. And again, I already told you, foreshadowing, he's going to testify. Auntie Bev denied Brennan's motion to exclude Wolfe and the other ARCCA witness from testifying in this trial. The defense won. He's in. But how?
about text messages. I don't recall how many there were.
All right. Was it 10, 100, 1,000? How many were there?
Probably
10,
I don't know,
100?
maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
You remember sitting down and deciding intentionally you were going to delete over 100 texts. Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you
Sir,
were?
I just said...
You don't delete them one by one. You just did the conversation, delete, and they're all poof, gone. Brennan, were you born yesterday? Come on, dude.
I delete texts routinely. You're asking me to specifically give you a location and a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
Did you ever communicate by any other means, like signal or an application?
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure. I mean, it's a messaging platform, yes.
Well, how many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations did you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible, so we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know. How many times did you use Signal with the defense to talk about this case?
From what I recall, it was probably a handful of times.
When you say what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right, I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means.
Probably around, probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal?
I think they were pretty brief. I'd say probably around 5 minutes or so.
Putting it on a timer, each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times in between 4 and 5
Oh my
minutes?
God, dude.
That's the best answer I can give you, sir.
Brennan thinks he's got something, but it is a complete nothing burger, and just watching him bury himself is so much fun.
My best estimate.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
During those 4 to 5 Signal communications, did any of these occur before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, did you think that the defense was going to compensate you for the cost of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill. I'm not.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
I'm a salaried employee, so it doesn't matter to
I'm
me.
a salaried employee. Brennan is asking I'm sorry, Mr. Wolfe, the grunt to answer for his boss. If you have a question, Brennan, call the boss. Why are you asking Wolfe information he's not privy to, man? That's not his responsibility. It's not in his job description. These are not his duties. That's not what he does. He's a salaried employee. That money doesn't go in his pocket. He's not the one who sends out the invoices. He gets a case. He investigates it. He does his job. He testifies. He's done. Deletes the text messages pursuant to the regular course of business. Where's the problem, bro? Hello? Hello? Anyone? Bueller? Brennan? Bueller? Hello? Anyone? What? And I'm telling you, folks, I am certain that when Brennan was up there, he was like, oh my God, I am about to cook this guy. And it just never came. Oh, this is so good.
My boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. You know. So, did you meet a person by the name of Kat?
I think when I arrived here, yes.
Kat worked for the defense?
I have no idea who she is.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
I'm going to allow it.
Pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. Near the church parking lot.
Which, by the way, that brings me to another question. I want to know who is paying Wolfe's travel arrangements. I hope Brennan is, because this is a waste of time. This is an absolute abomination, unnecessary, waste of the court's time, waste of resources. The jury would love to listen to testimony and evidence, but they can't because Brennan thinks he's got something when he's got absolutely nothing. Wow. I hope Brennan compensated Wolfe for his time instead of Jackson. It would be completely inappropriate for Jackson to have to front the bill for this garbage of testimony. Not testimony, but I mean like the questions. The testimony is great. It's completely normal, but Brennan is like just okay. Anyway,
With them.
Yes.
Okay. You shook his hand. This is meeting face to face.
Yes.
Right? Yes.
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
even Brennan's
At that
laughing.
point in time, no. I
Even
was
even Brennan's laughing. He realizes the absurdity of like he's got nothing.
getting ready to take the stand, so I don't think we had a conversation about it.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely.
I have secondhand embarrassment for Brennan. I'm gonna put my head in my palm.
I could certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there. We're going to get there, but there's a lot more
Okay.
communications before we get even close to that. And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talk about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir. That is the attachment to the email.
Do you recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers to him to ask you when you testified?
So this is something I routinely do when I work with attorneys, okay? I
Whoa,
prepare this
whoa,
on
whoa,
my
whoa,
own
whoa,
to
whoa, whoa,
prep
whoa, whoa,
myself
whoa,
and prepare-
hold on. What was that? Bev takes her glasses off. She is staring at Brennan. Brennan shakes his head. Auntie Bev nods and puts her glasses back on. Nonverbal communication between a lawyer prosecuting Karen Reed and the judge in the Karen Reed case. What? Watch this again.
No, sir. That is the attachment to the email.
Do you recognize reading that?
Yes.
Do you recognize
Glasses come off.
the case before you testified on June?
He's looking straight at the judge. He's
I
looking
never
straight at the
discussed this with
judge.
him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never
They're
asked this-
staring at each other. They're having a staring contest. Look at Bev. Bev is very intently. She's not listening to Wolfe anymore. She's trying to find a way to exclude him, and she's waiting for Brennan to clue her in. Watch this.
of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers to him to ask you when you testified?
So this is something I routinely do when I work with attorneys, okay? I prepare this on
There's
my
the-
own to
there's the
prep
head
myself
shake.
and prepare for trial.
Oh, I think I got it. I think I just got it. Why did he shake his head? I think if I were to bet money, if you were to ask me to put $10,000 bet, that's how much I'm willing to bet. That's how confident I am about this, what I'm about to tell you. $10,000 I would put right now, ready to lose it, because I think I would win it and walk away with $20,000. Listen to this. Brennan and Bev are having ex parte communications behind the scenes. Yes, I've just said it. That is a violation. Kind of like that judge in Georgia who was having ex parte communications with the prosecutor. I am convinced now, based on this interaction, those two are talking behind Jackson, Yannetti, Little, and Alessi's backs. Those two are having conversations about the trial. They can have conversations all day long. There is no problem with them going to golf and going to dinner. Prosecutor and a judge, I mean, impropriety, sure. But as long as they talk about, you know, how pretty the DUI guy's set is, how gorgeous the weather is, as long as they're talking about, oh, did you hear about, you know, the Jets and the whatever. I don't do sports, sorry. You know, the game that happened. They can talk all they want. What they cannot talk about is this trial. And here's where my bet is. You guys ready for this? You're not ready for this. I'm not ready for this. $10,000. I'll put it on the table right now for anybody who wants to take it, because you will lose. $10,000 says Brennan and Bev had a conversation before putting Wolfe on the stand that he's going to say, I'm going to crack him open. I have something. The text messages, I have something. The questions and answers, I have something, Bev. I have it. Give it to me. Let me do it. And Bev said, Brennan, no problem. I'll give it to you. I will force the defense to bring the ARCCA witnesses to court. On Friday, I think it was April 25th when this testimony happened. I will bring them to court, or at least Wolfe. I'll bring Wolfe to court. I will force Jackson to procure Wolfe, and I'm going to give you, you're going to have a field day. I'm going to give you carte blanche to do whatever you want. And right here, halfway through this clip, is Brennan conceding defeat. Basically, he's like, I have something. And after 12 minutes of questioning in this clip, it was longer in real time, because I'm giving you guys just the meat. I'm taking away the beans and the potatoes and the peas and the garnish, just so you guys can focus on the meat. So you get there's the Yiddish word tachlis. I'm giving you the tachlis of this case, because I don't want to waste your time. I want you guys to get the most important, crucial moments. And this right here is an absolute critical moment. The $10,000 bet is Brennan had a conversation with Bev. Said, Bev, give me 20 minutes with this guy. I will crack him open. Bev said, here you go. Friday, April 25th, ARCCA witnesses. Wolfe is taking the stand. Wolfe is on the stand. She is glaring at Brennan. Well, I gave you what you want. Are we good? Do you have him? Folks, we now have evidence of collusion. Evidence on video of collusion between Brennan and the judge. And I know I said, I want to play it one more time. This is a third time. This is how important it is. I want to play it a third time to make sure that everybody sees what I see. That I'm not just making it up, that I'm not just fabricating it, that I'm not just, this is huge. Evidence of collusion between the prosecutor and the judge. This is the first domino. See, Lally was a coward. Lally wasn't as cocky or confident. Brennan's confidence is going to be his downfall. Watch closely as Brennan shakes his head and Bev nods and looks down, putting her glasses back on, realizing, well, we tried. No, I'm sorry. I don't have him like I promised, Bev. Well, we tried. Notice I said we, not, well, you tried. No. We tried, because Bev is in on this. Everybody knows this by now. Wow. Oh, my God.
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Can I get back, please? There's an email with a document that like to attach this as an exhibit.
Okay.
So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question
Hold the comments, please.
my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
And by the way, it's routine practice. Every criminal defense attorney in this country worth their salt prepares a direct examination, question answer with their witnesses. You've done it. If you're a defense attorney, you know what I'm talking about. I've done it. Jackson's done it. Wolfe has done it with other cases. Brennan has done it. I know he has. Because if you haven't, you're a dumbass. Because there is nothing wrong with preparing your witness. I'm not going to tell them what to say because that's called coaching. Don't coach. Simply prepare. So, and then I'm going to say this because that's the fact of your case. Okay, fantastic. And then what? And then this. Okay, fantastic. There is no problem. This is routine. And Brennan knows this. He represented Whitey Bulger. He knows this stuff and he's making it look like a big... it's the same thing over and over.
The answer in the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand
Yes!
my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something?
What?
That's helpful? Do you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no comments, please.
Do you think that providing a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well.
Yes!
It would have been the same exact line whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Oh my God!
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document, you said you just sent it because this is a standard thing. Why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
Oh my God.
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
Objection, Your Honor. I'm going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely, and it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling
You guys, I cannot explain to you in how much pain I am in right now, how useless all of this is, how pointless, useless, and unnecessary all of this is. Just, it's doing nothing. Remember, Brennan has already conceded defeat like 10 minutes ago to Auntie Bev when he shook his head like, I don't have anything. But he has to keep it going. He has to keep the charade going because he signed up for this. He could have stopped the bleeding 10 minutes ago, but he just insists, no, I gotta finish this out.
us here under oath before this court that you did nothing to assist the defense. You do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No. Sir, there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution.
You guys!
But you're not taking sides, you're totally objective, right?
That is a question that's routinely raised when I testify about whether or not we inspected the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter.
It doesn't
to my
matter.
analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
Oh, you can tell. You can tell his raising his voice because he knows he's in a losing battle. That's the hallmark of a loser. He's raising his voice. And look at Wolfe. He's just like, bro, like, are you done? It's like that kid who thinks that if I yell louder than the other kid, then I'm going to be right. That's Brennan right now.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Did you write that?
Yes.
And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
Yeah, he's asking the wrong questions, Brennan is. He keeps saying, you're doing this to help the defense, and he's explaining Wolfe is doing a fantastic job. Just simply telling him what his job is. I am not here to say whatever the defense want me to say, you dumb nut. I'm here to say what I have concluded in my own investigation.
Enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury.
Yeah.
That's what I was trying to make sure that point was understood. To the jury.
You deferred to the defense, exercising discretion on what you will or will not say to the jury back then.
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on.
Let him answer.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because, for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to?
By the way, pay attention. Brennan's demeanor was here. Then it was here. He got the answer he didn't want, and now he's back here because he knows he's got nothing. He tried to fake elevate to. He went from like a 2 to a 7, and now he's back to a 2. Why? Because 7 didn't get him anywhere, and he realizes it's just a kid throwing a tantrum in court. It's so bad, but it's so good. It's fun to watch Brennan sinking his own ship. It's a lot of fun.
Call Mr. Klein.
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
It would be easier to understand if you could just tell us what the conversation was.
Oh my
That's what I'm asking about.
Oh my God.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, again, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction testimony?
No, sir.
Did you?
Because he didn't need to. And by the way, he could have. Even if he did, he's an expert witness. Expert witnesses can watch testimony and testify based on others' testimony. Expert witnesses are actually designed for that purpose. Some judges will still not let you, and this judge probably would have excluded him, and they knew that ahead of time. That's why I'm certain of it, that Jackson said, by the way, you know what happened. You did your investigation. You gave your report. You're going to give your testimony. Just to be safe, don't watch any of the testimony. Even though you can, just don't, because this judge will throw a fit, and we don't want to raise her ire. This is brilliant, the way the defense did this. Absolutely brilliant. I am so impressed. So impressed because Jackson knew from day one when he first hired the ARCCA witnesses, he knew from day one that they are going to, the prosecution and the judge are going to bend over backwards to try and screw it up for the defense. And look at that. They tried to exclude them from trial number 2 as well. And they failed and failed and failed and failed again. And defense won and won and won and won again. You know why? Because the defense are running a tight, clean ship. Like I said, there are 2 parties in this case. You have the defense and the prosecution. The prosecution consists of Alessi, Jackson, Yannetti, and Little. They're the ones prosecuting this case. On the defense side, you have Lally and Brennan. Yes, I said that correctly. I did not make a mistake. Brennan and Lally they're fighting for their lives in this case. They're fighting for their lives. They're trying to keep this momentum, whatever they have left of it, going. And it's dissipating with every ticking second. It is unbelievable how pathetic this case has become, especially in trial number 2. The desperation, the attempts at manipulation and lies have reached an unprecedented level. If you watched the earlier video with Jennifer McCabe, by the way, and if you haven't, why haven't you? You gotta go watch it, folks. And don't forget to subscribe to the channel so you don't miss the next Jennifer McCabe video tomorrow. Oh my God. We're gonna go over the text messages tomorrow. So yeah, do that. Oh my God. Why haven't you subscribed? Anyway, ARCCA is clean. They use Signal, so what? They deleted text messages, so what? He's not a party in this case. He's a witness. He's an expert witness. He routinely deletes messages, so what? Trial is over. You're going to call me again? I'll testify again. And I'll delete those messages too. Unless the court asks me to preserve them, then I'll save them. You didn't ask me. You screwed up. You didn't ask me to preserve any text message communications. You didn't do your job. Lally. And now Brennan has to clean up his mess. The prosecution's case is shoddy because they have nothing. That's why when I just say the prosecution, I'm talking about Brennan and Lally. But the real prosecutors are those four I talked about. Brennan and Lally are on the defense. They're fighting for their lives, trying to keep this case from like getting dismissed. Any judge in the universe besides Auntie Bev, who's in bed with the McAlberts, part of the Canton Mafia, if it was any other judge, this case would have been over a long, 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 long time ago. It's so sad and so pathetic.
Did the trial spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
Parties.
No, I went straight to the airport.
And, sir, is there any other communications that you've had with the defense that you didn't tell us about outside the texts and the phone calls and the signal calls? Or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
You're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Yes,
but you would agree you still have not provided any reports.
correct.
You said if you were
And by the way, far be it from me. I know I'm not the best looking guy on the planet, but what is going on with Brennan? Why does he look like a squirrel? I very rarely do I comment like on looks, but it's just the first thing I saw because I haven't really looked at Brennan speak like this before. I haven't had a chance. Let me know in the comments below if I'm totally off the mark and I'm being an asshole. Please tell me. But I don't know. He just kind of looks and talks like a squirrel. It's the only thing I can think about. I'm sorry. Not sorry. Just a thought. Let me know if I'm being a jerk in the comments below.
notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Are you aware of any effort by ARCCA or the defense to try to facilitate an agreement that the defense could use ARCCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCCA in December or January?
No.
And so as far as you knew, this came out of nowhere in March, that the defense wanted to use ARCCA, or specifically you and Dr. Renchelier, in late March of 2025.
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, he had indicated that the ARCCA issue was being litigated. And I think that, like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025, isn't that fair to say?
Correct.
Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
Oh, the Department of Justice is closely watching the trial and providing us with information. So that has not changed. So Brennan lying to the court that the feds have concluded this investigation from a now resigned, retired chief of police, by the way. Yeah, she's gone. That letter, like, oh, we're not doing this anymore. I'm telling you, folks, dominoes are falling in every direction. Every direction. If you don't know what I'm talking about, the chief of police of Canton, after like 30 some odd years of being on the force, resigned her position a month ago when the trial started. Literally like day one of the trial, like April 1st, I think it was, or March 30th or something like that. March 31st, like the day before, the day after. Go look it up. It was news. And she is the one who published a letter saying, I spoke to somebody who's an assistant U.S. attorney, and anyway, This one random person said, yeah, they're done looking at this case, meaning the feds. Turns out she was wrong, and now we know why she was wrong. Because she was lying. She just spoke to some rando. She didn't speak to someone who's involved directly in the investigation of this case. Jackson was right. Jackson said a few weeks ago, he said, after this case, our justice system is going to be changed forever. Now I'm starting to see what he meant when he said that. The level of collusion and corruption runs so deep. I remember I received word that the McAlbert Mafia operations run almost as deep as about 25,000 people. And it's generational. It's been going on for a very long time. A very long time.
What information were they providing you about the trial?
I think that they provided information regarding some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
One that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
You received from the Department of Justice with the defense?
No.
And is that how at trial, even though you had no evidence that was produced as part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
What other witnesses were you advised about their testimony and issues in this case before your...
I think I'm starting to learn the secondary goal of Bev forcing Wolfe on the stand this early on. They're trying to prepare their future testimony. They need to know what he knows because he can share what the feds know. He's extracting information ahead of time in anticipation. Oh my God. That's exactly what he's doing. It is a hidden tactic, folks. I've had this happen at least once in my trials, to put on a witness out of order, to voir dire them so that they can prepare their own witnesses better. Because the McAlberts can then listen to all of this and change their testimony accordingly to make sure that they're not going to run contradictory to what the feds already know. Dirty, 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 dirty.
Your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
More Brennan making himself look like a fool. Dude, did you even listen to Wolfe's testimony before you started asking questions? Clearly you haven't. How do you do that? How do you not prepare a direct examination, which is more like this is a cross-examination, obviously, because it's an adverse witness. It's a witness for the defense. So he's free to basically do cross-examination questions on direct examination. It's like permission to treat this witness as a hostile witness in a way. You know, it's normal. It's expected. No surprises there. But how do you not review his testimony from last year? Just press play on the video on the trial channel or something. And shout out to you guys, by the way, because I'm using your content again. Thank you so much. Go check them out. They're amazing. They're removing all the stuff, all the useless pauses and comments and everything on their channel, and it's fantastic. But anyway, how do you not review this, man? You know who's gonna need a lawyer at the end of this? Brennan. Brennan is going to need a good lawyer. And you know who's a good lawyer? We are. 1-844-774-HURT. Call us if you need us. We do cases all over the country. If you've been physically injured in any way, shape, or form because of someone else's negligence, we're happy to pick up the phone and help you out. So call us, 1-844-774-HURT. But you know who is going to need a lawyer? Brennan. Brennan is going to need a lawyer when this is all over. Why? Because he is going... I'm telling you, there's something coming. There is something coming. A lawyer who defended Whitey Bulger and now prosecuting Karen Reed, there is something coming. I don't know what it is yet, but there's something coming. Bookmark this. Mark my words. Something is coming.
No ability to really vet the reliability of your first experiments that led to your testimony and trial on this day.
I
We're
think
almost
you might be
done.
confused. Again, our role for this round.
I don't think
first,
I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
we
asking
have
you.
provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel attack.
This was one of the most embarrassing moments for Brennan I have ever seen in my entire life. Not just for Brennan, for the prosecution. That is the most embarrassing thing I have ever seen, folks. This is ridiculous. What a waste of time, energy, effort. And listen, if nothing else, you guys have entertainment fodder for the rest of your lives. Anytime you want to get a good laugh, just play this video. It will cheer you up. Brennan just looking stupid and idiotic and making a fool out of himself. And with that, folks, I will see you all in the next video. Bye, everybody.